can't tell you how excited I am to actually be talking about these topics, and there's a couple of reasons for that. The first reason is that I'm finally getting caught up. Talking about criminal law today. And what I mean by finally being caught up is that our professor ended up going to a school reunion, got sick there, came back, and so we ended up missing 2 weeks of criminal law. And came back and we did a makeup class. And let's just say I was a little slow in updating my outline and in getting these recorded. So we have criminal law being taught later today. But ultimately, I'm a week behind. So we talked about these topics that I'm going to be talking about. At least this morning, the 3 episodes that are going to come out this morning, we talked about last week. So it's not necessarily fresh in my mind, but I'm excited to talk about them, partially just because it's going to be a relief to get the guilt off of my chest that I am behind. So it'll be nice to finally be caught up on all my outlines, publishing these episodes, and ultimately to move forward and spend more time practicing and prepping for finals. So since it's been a while since talking about criminal law, our last episode we talked about self-defense. And we talked about the requirements for self-defense. And one of those requirements was to have a reasonable belief. Now we're actually going to be talking about what the reasonable belief standard is. And we have 2 cases to emphasize that. We have People v. Goetz, and then we have State v. Norman. What People v. Goetz entails, just very briefly, a little synopsis of the facts, is that Goetz was on the subway. He had been robbed before in the past. And as a result, he had purchased a gun. He had been threatened to be robbed after his purchase of the gun, but waving it would scare him away. What happened in this instance is that 4 gentlemen came onto the subway. One of them, actually 2 of them, stood up, approached him, and said, "Give me $5." Goetz had thought that this sounded threatening, so he got up, pulled out his gun, and shot the 4 men. And not only did he shoot the 4 men, but he missed the last one, noticed that he missed the last one, and shot him again. He was pretty angry. At trial, he was denied a specific instruction, or rather, there was an instruction provided where the prosecutor was asked, "What's a reasonable belief?" And the prosecutor said, "A reasonable belief is what a reasonable man would have done." So this is an objective test. And what Goetz argued at trial is that, hold up a second, this should be a subjective thing. This should be how I perceived it in my mind at the time of the shooting occurred. And this made it to the next court, which examines this issue. And they said that when the state was adopting its penal code, they were looking at the MPC. And the MPC is an entirely subjective standard, meaning you're going to look at the mind of the person in that situation and you're not going to look at anything else. However, when they adopted their penal code, they actually included the word reasonable belief. So MPC just says belief. New York, in this case, says reasonable belief. And so the courts say that adding this word reasonable adds the subjective standard. But you can still have a subjective standard along with this objective standard. So, how's this work? Well, you're going to first look into the mind of the person in that situation, and you're going to consider certain factors. Once you're in his mindset, you're going to say, would a reasonable person have acted the way that this person did? And that's how you do like a mixed objective and subjective standard. Let's talk about the subjective aspect of it. What things can we consider on a subjective level? What questions can we ask to get into the situation of the person who is there? Well, we can ask, what are they holding? Meaning, were the people who were attacking him holding anything threatening? Were they holding a knife? Were they holding, in this case, even a screwdriver? But that screwdriver was in his pocket, so did the person even notice the screwdriver to begin with? Can we ask how old they are? The answer to that is yes, because a young person is known to commit more crimes than elderly people. An old grandma sitting on the subway isn't likely to be a threat, whereas a young person, it could be. Likewise, we can ask the same question about gender. What about what are they wearing? Well, to take the extreme example, if somebody is in an orange jumpsuit on the subway, would you see them more as a threat than somebody who's in a suit on the subway? What about the way that they made their statements? The answer to that is yes. Can it be seen as a threat, or can it be seen as a plea? What about his past experiences? He had been robbed in the past. Should we consider that as well? And the answer to that is yes. Finally, and this was really the big question, can we ask about race? And I'm not going to get into that, but there are pros and cons to asking that question. And we debated about that in class, but I won't get into that anymore. One last takeaway from this case is what happens if you have a subjective belief, but the action was actually unreasonable. So the subjective belief is there, but you weren't objective, it was unreasonable. Ultimately, what's going to happen there is you're actually going to be convicted of a lesser crime. So if you're charged for murder, you have that subjective belief that you're under attack, your actions were unreasonable, you're likely going to be charged for manslaughter instead. Convicted of manslaughter. Our second case is State v. Norman. What happened in this case is that it was an extreme domestic violence situation. The wife had, after going through all her situations, ended up shooting her husband into sleep. And she had believed that eventually, didn't know when, that he would kill her and her family. And she was really preventing that in her mind. So the question that we have to ask is, can we ever claim self-defense against someone who is currently, in that moment, passive, meaning asleep, very violent in the past, knows that they are going to be violent in the future, and to a certainty, eventually is going to kill them? And this brings up a debate about immediate. The appellate court in this case said that her fear was immediate. The Supreme Court of North Carolina said that she was not in immediate danger because he was asleep. So is she entitled to a self-defense claim based off of her reasonable belief? And that is the question that lots of courts differ on. North Carolina had the chance to review that again, and they said that no, it needs to be immediate. It needs to be threatening you in that moment in order for you to act out of self-defense. And that's a summary of the self-defense reasonable standard. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is, if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, law scholars is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.